Article 32, Supreme Juridic Person. Canon 1619. A supreme juridic person is recorded and enrolled in the great roll of divine persons associated with a supreme divine trust registered with the great register and public record of one heaven as an aggregate of 100 divine persons formed as the body of a supreme trust when such divine persons share similar characteristics and no longer own a living flesh vessel. Canon 1620. There is no higher form of juridic person than a supreme juridic person. The highest supreme juridic person is the aggregate of all supreme juridic persons represented by the Society of One Heaven. Canon 1621. As all divine persons are formed from divine immortal spirits, supreme juridic persons possess conscience and legal personality as a living spirit. It is both illogical and fraudulent to compare a supreme juridic person with a corporate person, being a mort manus person, also known as a dead ghost devoid of conscience. Canon 1622. No inferior juridic person, also being corporate person, also known as a mort manus or dead ghost, can have superior jurisdiction over a living spirit. Therefore no inferior Roman juridic person may ever have superior jurisdiction over a supreme juridic person. Article 33, Universal Juridic Person. Canon 1623. A universal juridic person is recorded and enrolled in the great roll of divine persons associated with a universal trust registered with the great register and public record of one heaven. Canon 1624. A universal juridic person is the highest possible form of juridic society of any and all types of society within the universe. There are only two types universal juridic persons, namely Hokadaya and universal, gold, credits. Canon 1625. As all true persons are formed from divine persons themselves formed from divine immortal spirits, universal juridic persons possess conscience and legal personality as a living spirit. It is both illogical and fraudulent to compare a universal juridic person with a corporate person, being a mort manus person, also known as a dead ghost devoid of conscience. Canon 1626. No inferior juridic person, also being corporate person, also known as a mort manus or dead ghost, can have superior jurisdiction over a living spirit. Therefore no inferior Roman juridic person may ever have superior jurisdiction over a universal juridic person. Canon 1627. Hokadaya has dominion over all existence and all therein. Article 34, Global Juridic Person. Canon 1628. A global juridic person is recorded and enrolled in the great roll of true persons associated with a global trust registered with the great register and public record of one heaven on earth. Canon 1629. As global juridic persons are formed from divine persons holding conscience in life, all global juridic persons possess legal personality as living beings with a spirit. Canon 1630. No inferior juridic person, also being corporate person, also known as a mort manus or dead ghost, can have superior jurisdiction over a living spirit. Therefore no inferior Roman juridic person may ever have superior jurisdiction over a global juridic person. Article 35, Civil Juridic Person. Canon 1631. A civil juridic person is a superior person recorded and enrolled in the great roll of a valid Hokadaya society associated with a civil trust as a superior trust registered with the great register and public record of a valid Hokadaya society. Canon 1632. As civil juridic persons are formed from divine persons holding conscience and life, all civil juridic persons possess legal personality as living beings with a spirit. Canon 1633. No inferior juridic person, also being corporate person, also known as a mort manus or dead ghost, can have superior jurisdiction over a living spirit. Therefore no inferior Roman juridic person may ever have superior jurisdiction over a civil juridic person. Canon 1634. If two civil juridic persons are so joined that from them one is constituted, which also possesses juridic personality, this new juridic person obtains the goods and rights proper to the prior ones and assumes the obligations with which they were burdened. With regard to the allocation of goods in particular and to the fulfillment of obligations, however, the intention of the founders and donors as well as acquired rights must be respected. Canon 1635. If a civil juridic person is so divided either that a part of it is united with another civil juridic person or that a distinct civil juridic person is erected from the separated part, the authority competent to make the division, having observed before all else the intention of the founders and donors, the acquired rights, and the approved statutes, must take care personally or through an executor to the financial obligations and disbursement of remaining assets in accordance with the original intentions of the members. Article 36. Mercantile juridic person. Canon 1636. A mercantile juridic person is a superior person recorded and enrolled in the Great Roll of a valid Eucadiah society associated with a mercantile trust as a superior trust registered with the Great Register and public record of a valid Eucadiah society. Canon 1637. As mercantile juridic persons are formed from true persons themselves formed from divine persons, holding conscience and life, all mercantile juridic persons possess legal personality as living beings with a spirit. Canon 1638. No inferior juridic person also being corporate person, also known as a mort manus or dead ghost, can have superior jurisdiction over a living spirit. Therefore no inferior Roman juridic person may ever have superior jurisdiction over a mercantile juridic person. Canon 1639. If two mercantile juridic persons are so joined that from them one is constituted which also possesses juridic personality, this new juridic person obtains the goods and rights proper to the prior ones and assumes the obligations with which they were burdened. With regard to the allocation of goods in particular and to the fulfillment of obligations, however, the intention of the founders and donors as well as acquired rights must be respected. Canon 1640. If a mercantile juridic person is so divided either that a part of it is united with another mercantile juridic person or that a distinct mercantile juridic person is erected from the separated part, the authority competent to make the division, having observed before all else the intention of the founders and donors, the acquired rights, and the approved statutes, must take care personally or through an executor to the financial obligations and disbursement of remaining assets in accordance with the original intentions of the members. Article 37. Union juridic person. Canon 1641. A union juridic person is a superior person recorded and enrolled in the Great Roll of a valid Eucadiah society associated with a union trust as a superior trust registered with the Great Register and public record of a valid Eucadiah society. Canon 1642. As union juridic persons are formed from true persons themselves formed from divine persons, holding conscience and life, all union juridic persons possess legal personality as living beings with a spirit. Article 38. Inferior juridic person. Canon 1643. An inferior juridic person is an inferior aggregate person first created through a recording and enrollment in a roll defined by Western Roman statutes of law, or Roman body of law, or associated courts, tribunals and forums. Inferior juridic persons are the lowest standing and weakest of all valid forms of aggregate juridic persons. An inferior juridic person can never be validly, legitimately reasonably, logically, legally, lawfully, or morally claimed or argued as superior to a superior juridic person. Canon 1644. An inferior juridic person is by definition a corporation under Roman law, representing the body, corporate or the corpus of an estate. Therefore inferior juridic persons such as Roman persons are, by Roman law, considered mort manus, or dead ghosts in contravention of ancient principles of law, preventing such abominations ever permitting to have legal personality nor hold property. Canon 1645. By definition, an inferior juridic person is a dead ghost, devoid of life and spirit. Therefore an inferior juridic person can never have higher standing than a juridic person or persons that possess life and spirit. Canon 1646. Under inferior Roman law, an inferior juridic person may lawfully obtain and hold limited property rights only. An inferior juridic person can never lawfully obtain nor hold realty, real property. Canon 1647. An inferior juridic person cannot have nor claim the character of a moral person. Therefore an inferior juridic person cannot confer juridic personality. Canon 1648. In accordance with divine will, divine law, natural law and these canons, any person formed by laws originated and promulgated through claimed laws of the Roman cult and false Catholic doctrine is automatically an inferior juridic person. Canon 1649. In accordance with divine will, divine law, natural law and these canons, any person formed directly using Talmudic law is automatically an inferior juridic person. Article 39. Time. Canon 1650. Time is a fictional form of measurement belonging to an accepted form of reality defining a limited quantity of space and / or continued existence between two successive events or actions or the period through which an action, condition, or state continues. Canon 1651. The laws of time by natural law are not the same as the principles of time according to positive law. As time as a fictional form within a system of reality be suspended, elongated, or reduced. Canon 1652. The most superior form of time is the Hokkaidian time system as defined by the most sacred covenant, Pactum de Singularis Caelum. All other forms of time are inferior. Canon 1653. As the Hokkaidian time system is in harmony with the true cycles of the earth and the most ancient time keeping systems of the oldest priest-king bloodlines, the Hokkaidian time system also represents the one true and only valid time system. Canon 1654. Consistent with the acceptance by Roman law, Talmudic law, and Sharia law that such inferior time systems will be lawfully abrogated at the end of days, all three time systems are hereby rendered null and void. Therefore, the use of Roman time, Talmudic time, Islamic time, or another time system on an official form has no effect. Canon 1655. As Roman time is hereby rendered null and void, all claimed authority, power, right, and influence derived from this system is also hereby rendered null and void. Canon 1656. The use of any other time system other than the Hokkaidian time system for official and valid form is forbidden, except when documents are produced specifically for use in inferior jurisdictions. Article Article 40, Machine. Canon 1657. A machine is a device containing one or more inorganic moving parts capable of harnessing, transmitting or modifying energy. A machine may also be correctly defined as a good. Canon 1658. A valid machine is any machine whereby its make and model, including blueprints, are properly registered, it possesses a nameplate and has been tested and certified to be mechanically sound to Its registered specifications. Canon 1659. As all machines are built from objects and concepts, all machines by default are held in trust in accordance with these canons and the sacred covenant Pactum de Singularis Caelum, consistent will. All objects and concepts. Canon 1660. A machine that is not properly registered with the Hokkaidan Society in accordance with these canons is an unregistered machine. Canon 1661. An unregistered machine has no rights to use or be used on or with the property of a Hokkaidan Society. Article 41, Register. Canon 1662. A register is a ledger of records into which regular entries are made of details of form regarded as sufficiently important to be exactly recorded. Hence, for anything to be regarded to be on the record is literally to be recorded into a register. Canon 1663. A valid register has a specific purpose, level of importance relative to other registers, condition of entry and conditions of transfer of certain rights in accordance to valid law or statute. When two registers are compared, the one having superior standing in law has rights over the other register. Canon 1664. The highest and supreme register of all possible registers is the Great Register of One Heaven in accordance with Pactum de Singularis Caelum. Any law claiming equal or higher standing to the Great Register of One Heaven is automatically null and void from the beginning. Article 42, Record. Canon 1665. A record is a written memorial of some form of event and actions, an account under attestation or oath as fact, and the conveyance of proof of the such fact then preserved as knowledge and authentic history of the cause within entries united by some identified within a memorandum, journal or affidavit and certificate or summary. Canon 1666. A valid record in the Great Register and Public Record of One Heaven, also known as the Great Roll of Divine Persons, also known as the Great Book of Souls, also known as the Great Book of Life, also known as the Great Record of Time, also known as the Great Book of Perfect Divine Notarial Procedure, also known as the Great Book of Divine Law, comprises of 3 actions entered into 3 spiritual books, consistent with the etymology of record from 2 Latin words re-meaning property, and cordis means heart, body, mind, thought and reason, and spirit, soul. The event as the sign is the first action, entered into a memorandum of Hokkaidan space and time as a true written memorial to the event and associated proceedings and actions, and proven by the unique existence of a 18-digit Hokkaidan space-time number, and 2. The register entry as the sacred seal is the second action, as attestation to a true summary of facts associated with the original memorandum of event and unique 18-digit Hokkaidan space time number, and 3. The conveyance as the delivery is the third action, as proof of a valid event and account to a ledger as a true account by a certificate or letter or gazette posting, or all 3, connected to the register entry and the unique 18-digit Hokkaidan space-time number. Canon 1667. No inferior person or inferior juridic person is permitted to be ever entered as a record in the Great Register and Public Record of One Heaven, except when such an entry is recognition of reversion and recovery of all rights, title, instruments, certificates, uses, property, claims, trusts, deeds, estates, symbols, seals, powers, authorities, commissions, sacraments, funds, franchises, records, assurances, and securities from such an inferior person or inferior juridic person back to the Society of One Heaven. Canon 1668. In accord with these canons, any entry of an inferior person or inferior juridic person into the Great Register and Public Record of One Heaven, is absolute acknowledgement, agreement, consent, approval and acceptance that any and all rights, title, instruments, certificates, uses, property, trusts, deeds, estates, symbols, seals, powers, authorities, commissions, sacraments, funds, franchises, records, assurances, and securities claimed, or possessed, or held by such an entity is subject first to the rules and canons of one heaven above all other law. Article 43, Value. Canon 1669. Value is a fictional form being the assignment of a degree of importance, desire, and numerical value in currency to a particular form. Hence, value is a subjective ranking of a form relative to other forms, often on simple monetary value. Canon 1670. A good is worth as much as the value at which it can reasonably be sold. Canon 1671. The most important, the rarest, and therefore the most valuable form in history is objects believed to be divinely inspired and sacred. Canon 1672. The least important, the commonest, and therefore the least valuable form is objects and matter, considered to be abundant and easily available. Canon 1673. By definition, the most valuable form of all possible forms is these canons and the sacred covenant. Pactum de singularis caelum. No object, nor form may be considered more valuable. Canon 1674. No man, woman, person, aggregate, entity or spirit may claim ownership of the sacred covenant. Pactum de singularis caelum other than the divine creator. All copies, reproductions, abstracts and extracts of the sacred covenant remain at all times the sole property of the divine creator. Article 44, Asset. Canon 1675. In a general sense, an asset is a fictional form representing other forms regarded to possess a formal unique identity and value. As such, an asset is a net store of real value. Canon 1676. In a formal sense, an asset is any sufficient effects, property, or goods of sufficient value enough to discharge any burden cast upon a trust or estate in satisfying its debts. Therefore, assets do not exist without some relationship to a trust or estate. Canon 1677. Assets may be defined as either tangible or intangible. Canon 1678. A tangible asset is any asset, such as buildings, land, equipment etc. that has physical form. Canon 1679. An intangible asset is intangible personal property, acquired for money, that does not have a face value or a ready market. An intangible asset is also defined as any valuable property of a business that does not appear on the balance sheet, including intellectual property, customer lists, and goodwill. Article 45, Debt. Canon 1680. In a general sense, a debt is a fictional form representing an obligation by one or more persons, due to another one or more persons, whether it be to perform an act, or make payment of certain currency, goods, or effects. Canon 1681. In a form sense, a debt is a form possessing negative value that may only be effectively discharged, providing assets of sufficient value exist within the trust or estate to render a zero balance or remainder in the accounts.